the legislative branch.
Section 40. Journals. When vote to be entered. Each House of the General Assembly shall keep and publish daily a journal of its proceedings, and the yeas and nays of the members on any question shall, at the desire of any two of the members elected, be entered on the journal. The first three constitutions specified weekly publication of the legislative journal, and only the first allowed the General Assembly to exclude matters requiring secrecy. Although some delegates at the Constitutional Convention of 1890 to 1891 complained that allowing two members to call for yeas and nays gave rise to many filibustering, most believed that employing recorded votes served to restrain the big spending tendencies of legislative majorities. In 1900, the Kentucky Court of Appeals, citing Section 40, rejected a petition alleging that the legislative journals had been tampered with in order to support J.W.C. Beckham's claim to the governorship. The court ruled that the judiciary must presume that entries in legislative journals are valid and cannot launch an inquiry regarding their integrity, in Taylor v. Beckham. In 1980, the Kentucky Supreme Court held that the legislative journals and other evidence could be used to impeach the validity of an enrolled bill, thus overruling a series of cases that had adopted the enrolled bill doctrine, which asserted a conclusive presumption that an enrolled bill was valid, in D.W. Auto Supply v. Department of Revenue. Section 41. Adjournment during session. Neither House, during the session of the General Assembly, shall, without the consent of the other, adjourn for more than 3 days, nor to any other place than that in which it may be sitting. Nearly identical provisions can be found in the previous constitutions, as well as the federal constitution. The Kentucky Court of Appeals has declared that the purpose of Section 41 is to guarantee the absolute independence of the legislative branch of government, and that an attempt by the governor to adjourn the legislature without its consent and in the absence of disagreement between the two branches is unconstitutional, in Taylor v. Beckham, 1900. Section 41 is modeled after a similar provision in the federal constitution, which was inserted to prevent a repetition of the colonial experience when the royal governors could legally adjourn or even dissolve the legislature without its consent. Section 80 authorizes the governor to adjourn the legislature only if the two houses are in disagreement with respect to the time of adjournment, and then only for a period not exceeding 4 months.
Section 42. Compensation of members. Length of sessions. Legislative day. The members of the General Assembly shall severally receive from the State Treasury compensation for their services, provided no change shall take effect during the session at which it is made. Nor shall a session occurring in odd-numbered years extend beyond March 30th. Nor shall a session of the General Assembly occurring in even-numbered years continue beyond 60 legislative days, nor shall it extend beyond April 15th. These limitations as to length of sessions shall not apply to the Senate when sitting as a court of impeachment. A legislative day shall be construed to mean a calendar day, exclusive of Sundays, legal holidays, or any day on which neither house meets. This section was ratified as an amendment on November 7, 2000. The first two constitutions called for annual legislative sessions with no limits on their length. By the mid-19th century, complaints had arisen about the length and expense of sessions, which prompted the framers of the Third Constitution to limit regular sessions to 60 days biannually. Legislatures often took advantage of the proviso that 2/3 of the total membership of each house could extend sessions beyond 60 days, the session immediately preceding the convention having lasted 149 days. The framers of the 1891 Constitution imposed an unconditional 60-day limit on biannual sessions, believing that was sufficient time because they had eliminated the authority of the General Assembly to enact private and local legislation, a practice that accounted for most of the legislative business. Modern legislatures contended that they could not adequately accomplish their legislative responsibilities in biannual 60-day sessions and unsuccessfully proposed constitutional amendments in 1969, 1973, and 1998 that would have authorized annual sessions. In 1979, the voters approved an amendment that permitted the General Assembly to adjourn before the 60-day period expired and then reconvene in order to consider the governor's vetoes. The amendment also eliminated specific legislative pay provisions, which had been inserted in each of the 3 previous constitutions and in the original version of the current charter. Section 43. privileges from arrest and from questioning as to speech or debate. The members of the General Assembly shall, in all cases except treason, felony, breach or surety of the peace, be privileged from arrest during their attendance on the sessions of their respective houses, and in going to and returning from the same, and for any speech or debate in either house they shall not be questioned in any other place. This section represents a basic legislative right, which was won by the English House of Commons and colonial assemblies and carried over to the federal constitution and the state constitutions, including the 3 previous Kentucky charters. It especially guarantees the right of free speech and debate to ensure that legislators can openly and unconditionally discuss pending legislation without fear of arrest and prosecution, and as such constitutes a cornerstone of a free and effective legislature. The Kentucky judiciary has ruled that the section provides immunity to senators from civil liability for their votes to reject a nominee for an administrative judicial appointment, in Crouse v. Kentucky State Senate, 1994, and to legislators from suits brought against them in their official capacity on the basis of legislation on which they acted, in Wiggins v. Stewart, 1984. However, the courts have also held that the immunity does not apply to public offenses or against service of process in a civil action not requiring bail.
Section 44. Ineligibility of members to civil office created or given increased compensation during term. No senator or representative shall, during the term for which he was elected, nor for 1 year thereafter, be appointed or elected to any civil office of profit in this Commonwealth, which shall have been created, or the emoluments of which shall have been increased, during the said term, except to such offices as may be filled by the election of the people. All 3 previous constitutions contain similar provisions, the original having been taken from the Pennsylvania Constitution of 1790, which did not include the exception for popularly elective office. The section prohibits legislators from being appointed or legislatively elected to any office that has been created by the General Assembly during their term or the salary of which has been increased during that term. Under common law, it was illegal to hold incompatible offices, incompatibility being defined as creating a conflict of interest or divided loyalties. The General Assembly has, by statute, delineated offices that are incompatible with one another and provided that the acceptance of an incompatible office operates to vacate the first. The Kentucky Court of Appeals has held that a legislator who took his oath of office several hours after the governor signed an act creating the position of assistant county attorney could later, in the same year, accept appointment to that office, in Meredith v. Kaufman, 1943. The court also has ruled that the manager for the State Fair Board is a public office under this section, and therefore a person who was a member of the legislature that created the office could not fill it, in Taylor v. Commonwealth, 1947. However, it ruled that it is not a violation of this section for a school principal to serve in the legislature. Section 45. Collector of public money ineligible, unless he has quietus. No person who may have been a collector of taxes or public monies for the Commonwealth, or for any county, city, town or district, or the assistant or deputy of such collector, shall be eligible to the General Assembly, unless he shall have obtained a quietus 6 months before the election for the amount of such collection, and for all public monies for which he may have been responsible. Similar provisions can be found in the Second and Third Constitutions, although they applied only to state tax collectors. The provision was added to the Second Constitution and retained in the Third and current charters as a method to ensure that collectors of taxes and other monies who wish to be candidates for the General Assembly first fully collected or accounted for all taxes and other monies for which they were responsible. No published judicial decisions deal with this section. The Attorney General has issued an opinion that declares that sheriffs as well as other tax collectors are subject to this section, but sheriffs can become candidates for the legislature in a primary election and obtain their quietus for all taxes collected up to a date 6 months before the date of the general election. If the sheriff resigns before beginning the next tax collections, he or she would not be ineligible unless, during the period following the quietus, he or she collects taxes, in which event the eligibility would be in question.
Section 46. Bills must be reported by committee, printed, and read. How bill called from committee. Votes required for passage. No bill shall be considered for final passage unless the same has been reported by a committee and printed for the use of the members. Every bill shall be read at length on 3 different days in each house, but the second and third readings may be dispensed with by a majority of all the members elected to the House in which the bill is pending. But whenever a committee refuses or fails to report a bill submitted to it in a reasonable time, the same may be called up by any member, and be considered in the same manner it would have been considered if it had been reported. No bill shall become a law unless, on its final passage, it receives the votes of at least 2/5 of the members elected to each House, and a majority of the members voting, the vote to be taken by yeas and nays and entered in the journal, provided, any act or resolution for the appropriation of money or the creation of debt shall, on its final passage, receive the votes of a majority of all the members elected to each House. The second and third constitutions provided for 3 separate readings of bills in each House unless 4/5 voted to waive the requirement. The third constitution also specified that a majority of the total membership of each House had to approve appropriations and indebtedness in excess of $100 with a recording of the yeas and nays. The framers of the current Constitution added the requirement of 1 compulsory reading in response to complaints that the post-Civil War General Assembly routinely waived the reading of bills, even major ones, and rushed them to passage without adequate knowledge of their contents. Recording the yeas and nays of final passage would also provide accountability. The framers added the requirement of 2/5 approval of non-appropriation or non-debt legislation because they believed the existing constitution allowed too few legislators to enact such statutes. Only a majority of a quorum, as few as 26 of 100 representatives or 10 of 38 senators. One of the most significant decisions of the Kentucky judiciary concerning Section 46 involved another of its innovations, which permits a single member of either house to call up a bill if the committee to which the bill has been referred has failed or refused to do so in a reasonable time. The Kentucky Supreme Court considerably weakened that provision when it upheld a Senate rule allowing the full body to determine what was a reasonable time, in Philpott v. Haviland, 1994. The courts have also held that the Senate did not violate Section 46 when it gave a bill its first reading on the same day it passed the House, in Kavanaugh v. Chandler, 1934, and that Section 46 does not apply to municipal legislative bodies such as municipal boards. The Kentucky Supreme Court invalidated the Litter Control Act of 1978 because it did not receive the approval of a majority of all of the members of the House, as required for an appropriation bill by Section 46. Section 47. Bills to raise revenue must originate in House of Representatives. All bills for raising revenue shall originate in the House of Representatives, but the Senate may propose amendments thereto, provided, no new matter shall be introduced, under color of amendment, which does not relate to raising revenue. Very similar language appeared in the second and third constitutions, and a more simplified version appeared in the first constitution without the provision about new matter. Section 47 and its predecessors embody a basic right won by the colonial Houses of Representatives, the Assemblies, as well as by the lower house of the British Parliament, the House of Commons. A similar provision exists in the federal constitution. The Kentucky judiciary has ruled that a statute authorizing the budget to be introduced as a joint resolution violates Section 47, which requires that the budget be introduced in the House as a bill, in Legislative Research Commission v. Brown, 1984. Similarly, a bill imposing a tax on rectified spirits is a revenue measure, not a police regulation, and therefore must be introduced in the House, in H. A. Thurman Company v. Commonwealth, 1906. However, a license tax or a tax imposed for the maintenance of a municipal corporation may originate in the Senate.
Section 48. Resources of sinking fund not to be diminished. Preservation of fund. The General Assembly shall have no power to enact laws to diminish the resources of the sinking fund as now established by law until the debt of the Commonwealth be paid, but may enact laws to increase them, and the whole resources of said fund, from year to year, shall be sacredly set apart and applied to the payment of the interest and principal of the state debt, and to no other use or purpose, until the whole debt of the state is fully satisfied. The framers of the Third Constitution originally wrote this provision to prevent legislative tampering with a special fund that had been created to pay off the state debt contracted during the period of the Second Constitution, largely to invest in turnpikes and river improvements. The Kentucky Court of Appeals held that the commissioners of the sinking fund have no authority to provide funds for reconstruction of a building of the Industrial College for Colored People after it was destroyed by fire, in Rhodes v. Fields, 1927. Section 49. Power to contract debts. Limit. The General Assembly may contract debts to meet casual deficits or failures in the revenue, but such debts, direct or contingent, singly or in the aggregate, shall not at any time exceed $500,000, and the monies arising from loans creating such debts shall be applied only to the purpose or purposes for which they were obtained, or to repay such debts. Provided, the General Assembly may contract debts to repel invasion, suppress insurrection, or, if hostilities are threatened, provide for the public defense. During the first half of the 19th century, the General Assembly borrowed over $5 million and invested it in transportation projects such as turnpikes and river improvements. Some of these investments failed, prompting public outrage and a demand to limit future state indebtedness as a part of constitutional reform. The framers of the Third Constitution inserted the original version of this provision as a response to that demand, and the drafters of the current Constitution incorporated the provision almost verbatim. The Kentucky judiciary has ruled that revenue bonds, interest-bearing warrants, and holding company bonds that are not guaranteed by the full faith and credit of the Commonwealth, but are funded solely by the revenue generated by the projects the bonds are sold to finance do not constitute debts covered by this section, in J.D. Van Hooser Company v. University of Kentucky, 1936. Thus, bonds that were not approved by the voters, but were nonetheless issued for the construction and repair of roads, and that were secured by a lease arrangement between the Commonwealth and the Turnpike Authority, and to be funded exclusively by revenue from rental payments on the lease, were held not in violation of Section 49, in Wilson v. Kentucky Transportation Cabinet. 1994, on the other hand, borrowing not approved by voters that pledges the credit of the Commonwealth violates the section, in State Highway Commission v. King, 1935. Revenue bonds constitute the major way in which the General Assembly borrows money to finance capital improvements. The judiciary has defined casual deficits or failures in the revenue as a deficit or deficits happening by chance or accident and without any design to avoid the constitutional inhibitions of the state against incurring an authorized expenditure of the state's funds above a certain amount, in State Budget Commission v. Lebus, 1932.
Section 50. Purposes for which debt may be contracted. Tax to discharge. Public vote. No act of the General Assembly shall authorize any debt to be contracted on behalf of the Commonwealth except for the purposes mentioned in Section 49, unless provision be made therein to levy and collect an annual tax sufficient to pay the interest stipulated, and to discharge the debt within 30 years, nor shall such act take effect until it shall have been submitted to the people at a general election, and shall have received a majority of all the votes cast for and against it, provided. The General Assembly may contract debts by borrowing money to pay any part of the debt of the state, without submission to the people, and without making provision in the act authorizing the same for a tax to discharge the debt so contracted, or the interest thereon. The framers of the Third Constitution wrote this provision to ensure that the General Assembly would not borrow money in excess of $500,000 per year without first securing voter approval in a general election, and the drafters of the current Constitution incorporated the provision almost verbatim. The Kentucky Supreme Court invalidated that part of a statute that committed future general revenues to a malpractice claims fund because it amounted to the lending of credit of the Commonwealth in violation of Section 50, in McDuffie v. Hall, 1977. The Kentucky judiciary has ruled that the final clause of Section 50 means that voter approval was not required for legislative borrowing to pay off the state debt that was in existence at the time the Constitution was adopted, in Stanley v. Townsend, 1916. Thank you for viewing this history of the Kentucky Constitution. For more information, please see the following references. Citizen's Guide to the Kentucky Constitution by the Legislative Research Commission, available online. Or the book, The Kentucky State Constitution, by Robert M. Ireland, Oxford University Press.